Well, hello, everybody, and welcome to the Legally Yours LYCPD session. And today is all going to be on negotiation techniques. And we have got, obviously, the incredible guru. I'm calling you a negotiation and mediation guru, Elise Margow, with us today. But before I get started into formal proceedings, in the spirit of reconciliation, I'd like to acknowledge the traditional custodians of the land that I'm standing on here today, which is the Boon Boon Rawong and the Wurundjeri Woiwurrung peoples of the Eastern Kulin Nation. And I acknowledge and honour the unbroken spiritual, cultural and political connection peoples of the Eastern Kulin have had to this unique place for more than 2,000 generations. And I acknowledge that sovereignty of this land was never ceded. It always was and always will be Aboriginal land. And I pay respect to their elders past and present and extend that respect to all Aboriginal and Torres Strait Islander people of today. Now, this session will be hosted in our LY Hub CPD library. We have clocked over, I think, this will be our 76th hour of on-demand content that you can access there. We've got sessions on all sorts of different topics, which has been specifically catered and designed towards small law and your issues and innovative practice and services and pricing and all the rest of it. So please go ahead to the LY Hub CPD library and check it out, and you'll find this session here. But on to today's session. So this is going to be a Q&A style masterclass, and negotiation and mediation expert Elise Margow from Confidentially Speaking is going to talk us through her negotiation techniques that we can use to effectively negotiate commercially practical and sustainable resolutions to disputes for ourselves and our clients, and I'm sure even with our team members too. Elise is an experienced commercial lawyer and accredited award-winning mediator with vast litigation experience. Elise has broad legal and business expertise, being an alumnus of Telstra Corporation Limited and Arnold, Bloch, Leibler, as well as heading up legal teams. Elise has contributed on credit and due diligence committees, is director of 2 companies and has company secretarial experience. And over the past 16 years, Elise has focused on alternative dispute resolution techniques to assist clients and disputing parties avoid lengthy and expensive court proceedings, as well as helping entrepreneurs, small to medium businesses in negotiating significant deals. As the principal of Legally Speaking and the founder and CEO of Confidentially Speaking, Elise brings her commercial experiences together with a pragmatic approach to assist SMEs in negotiation preparation and resolution of disputes. And Elise was named one of the top 100 most passionate, powerful and provocative personalities of 2012 by the Age Melbourne Magazine. But you've got even more awards. You're on the Doyle's list and all of those sorts of things too, aren't you?
Yeah, I think I need to take that out. It's a bit old.
No, but you know what? I love saying it. So no, we're going to keep that one in. But you're also, you've been on the Doyle's list a billion times, and you're just incredible. So Elise, I'm going to hand over to you. Why don't you just sort of give anything that I've missed out on that intro and perhaps a little bit more info on Confidentially Speaking as well, and then we can get into some questions.
Okay, so that was quite boring, I'm sure, to hear all that background. So I'll go straight into why I became this, I hate to use the word passionate, but this passionate advocate of in negotiating properly and commercially. And that came from years of experience, both from when I was negotiating deals and still am negotiating deals, and then sitting representing parties in litigation when we're trying to resolve and mediations, and then as a mediator. And it was really bugging me that people would come to mediation or a business discussion and they wouldn't be prepared. So you'd ask them basic questions like, well, how do you get to that figure? Why do you want this? What is going on? And they wouldn't really be able to answer except to say, I want this. And so I felt that there was something lacking. And I think part of that is certainly with litigation lawyers, the concentration is on the litigation. It's going to court, but not the negotiation. So the negotiation is seen as a step on the way to the steps of court. And when we're on the steps of court, then we'll seriously negotiate. And so I started saying there's a gap in the market. We really need to start talking seriously about preparation for negotiation and negotiation techniques. And I didn't mean the Harvard getting to yes that everybody's read or throwing academic terms around. I really wanted something practical. And that's why I created Confidentially Speaking over time. Part of it is to give parties an online tool to prepare for negotiation by themselves, but also to have support if they didn't know they didn't feel confident in doing things themselves. And the idea is once you use our techniques, we want you coming back, but to advance in your negotiation techniques, not to always need our help, always come, or always feel like you're starting from the beginning. So it's a training ground. And that the other part of it is I don't think people are really practical necessarily in negotiation. So it's changing the mindset to being more practical.
I absolutely love it. And where can you go to check this out? Because you've got some great videos. And you've also done a demo video as being a woman of Australian legal tech. So Elise is also a fellow Walter member as well. You've done an incredible video, haven't you, too, that people can access?
Yeah, so if you go to our website, www.confidentiallyspeaking.com.au, which Karen can put in the chat, we have all that gives the basis of confidentially speaking. But every week we also put out a negotiation tip on our LinkedIn page. So if you want to join Confidentially Speaking on LinkedIn and follow us, we actually give a tip every week,
which I just love. And this is what we're going to do. So today, this is, as I mentioned, very Q&A style, and we're going to give lots of opportunity for everyone to ask their questions, but I might start things going. So I've actually pulled some of your negotiation tips because I love them actually. The one I want to start off with, which actually kind of made me have a little chuckle, but there was one you put up that said, make sure I won't swear, BS.
You can.
Oh, can I? No.
Oh, please swear.
Bullshit radar is switched on and tuned up. So make sure your bullshit radar is switched on and tuned up. What do you mean by that? And talk us through a little bit about sort of, how you can actually do that. Because what you actually teach is, yes, great, but it can be equally applicable for team members and when you're going to any form of negotiation. So tell me a little bit about what you meant by that tip.
So basically, whenever they teach negotiation, the assumption is everybody is going to play by the rules and everybody is going to play nice and they're going to give us all their, I'm going to give you my positions and I'm going to give you my fact statement. And you've got that list of academic negotiation tips. But the reality is people can be very clever. Some of them can be a little bit dodgy. And you've got to be able to pick up when someone's telling you something where they actually mean what they say and you can take what they say seriously and work with it, or when they're bullshitting you. And so when I say that bullshit radar, you have someone say, well, of course it's going to cost me $1 million to do this. And, they bring in so-called experts. And when you you scratch the surface, those experts aren't really experts. You haven't done your basic concept. So it's both psychologically looking at the person and being able to see whether they're playing poker, but it's also what are they giving you? Is it really of substance, or are they just bullshitting you? And they speak well. Always the good speaker, the charmers. Look. I'm not saying every charmer is bullshitting you, but just look seriously at what they say.
I really like that. And also there's that feeling, isn't it? There's that sort of feeling. And as again, Barry, Tremaine, please feel free to kind of put in your thoughts on this topic as well. But there's that feeling that you get as well where you're like, yeah, this isn't really sitting well. And I think sometimes we kind of push that away to think, no, I'm sure, why would they do that? I'm sure that it's the real deal. But sometimes listening to that little, like you say, the radar, love it.
Can I just make just a couple of comments if I can, Elise? And first, I've for many years been on a bit of a campaign to stop this ADR meaning, because what you said, which is what everyone says, is it's alternate dispute resolution. I take issue with that because that means that we all focus on litigation is the way to go, and whatever else there may be, conciliation, facilitation, collaboration, mediation, all of the other shuns, as I call them, are alternate to litigation. And I have an issue of, why is it alternate? Why aren't we not all in dispute resolution? Why don't we make, in fact, litigation the alternate dispute resolution? And the main resolution is the other shuns I've said. So that's point number one. And I 1,000%
agree with you, Barry. Continue.
Yeah, and you know, I don't think in my lifetime it will change as a perception by everybody, because litigation is sexy. It's fantastic. Everyone wants to wear a suit and go into court, and men too. Then there is the issue of, and I love the concept you made of the preparation for dispute resolution, whether I call it mediation or facilitation or collaboration. And it's true that a lot of people, lawyers in this space, and I come from a relationship and family law background, right? So that's where our dispute resolution is. So many people just regard it as two things. One is it's a dress rehearsal for court. So you go in with your, I'm going to run my case in a mediation concept. And secondly, it's a ticker box so that in family law world, we can issue proceedings, because we've got pre-action procedures which require there to be some dispute resolution beforehand. So you don't get parties or people really playing in the space for the reason that it should be there. Some do, but again, there is this concept, I think, of it's a cousin, it's a poor cousin to what's really important in the world of dispute resolution, which is getting to some stranger making a decision for two people based on principles that are very interesting but don't have really much to do with an outcome for the parties.
I agree with so much with that. So there are two things I take where I take it further. So, you know, when they talk about preparing, they always use the word BATNA, your best alternative to a negotiated agreement, and they mean by that court. So what would your best alternative to a negotiated agreement be? We're going to court because then if we win, we get everything. I say that's, can I say the bullshit radar comes up? Because basically it's absolute rubbish. I say, you know, the best alternative is you get everything you could possibly want, and that might not be available within the law, because the law in my mind is a corset. The courts themselves are set up by a statute, and they can only operate within the realms of the statute and the regulations. What they can actually argue about is also that. So when you are before court, you can only ask what the law says you can ask, and the judge can only make a decision based on what is either in statute or common law. And so if, for example, you want something like, I would love a really good commercial relationship with this person ongoing and we need to work this out, or I want them to introduce me to someone, or I just want to get on with my life without this coming along, or I want an apology, that's not available to the judge. So that's not the best alternative. You might get your money plus an apology, or a business relationship. So that's, that's exactly the problem with the way they think. And again, as you say, court should always be the last alternative to anything, because I love what you said, is it's a third party who doesn't know you making a decision that's going to affect your life. And who would want that? You know, in practical terms, but for lawyers, and this is the interesting thing, and as a litigation lawyer, it's really hard. I'm not saying you're in bad faith, but you're thinking, if I keep going, the closer I get to court, the more money I'm going to make. So if I come up right at the beginning and I call the parties together and we go in full metal, try and resolve, do things properly, at the end of the day, I'm going to get maybe a tenth of the fees I'd get than if it went all the way to court. Now, as I said, I don't think people think of it like that or in bad faith, but there is something about that, which means the whole system is predicated on the longer we go in the dispute, the better it is for the lawyers.
Yeah. And there is an inbuilt conflict there, you're right, conflict for lawyers. But by the same token, if we were to take that and turn it around so that lawyers don't feel conflicted and in fact feel as though they get something out of it, we then go to, well, what should a proper dispute resolution methodology look like? And the answer is, don't just treat it as fluffing around the edges and see what may happen. Do actual preparation for a mediation as if you were preparing for a court, as you've said. And in fact, we've just introduced in our dispute resolution mediations, a concept that we say something that's so obvious, but other lawyers we've spoken to think it's a great idea, and we call it a pre-mediation preparation meeting.
Yeah, well, that's it.
PMPM.
Yeah, we call it intake, but yes.
No, well, our intake is different. Our intake is to meet with the parties themselves, but you call it intake, same sort of thing. It's like a directions hearing in court. Where are you at? What needs to be prepared? If it's valuations, have you got your valuations? Have you exchanged all the relevant documents? Are you in a position to discuss outcome, or are you just fluffing around and, as you say, talking bullshit just because it'll make you a bit of money and then you'll show the other person how smart you are, etc. So the preparation concept is not very well known in our jurisdiction. Lawyers think they know because, of course, they're smart and they do prepare, but they don't necessarily prepare according to a structure, which is what's so good about court, isn't it? Because court gives you a structure. It is a conveyor belt, and you have to stop along the way and do certain things and require, because if you get before a judge and you haven't, well, then all hell will break loose. In a mediation, the mediator doesn't have that sort of power or ability. The mediator is a neutral facilitator, not a director, tries to be, but if they don't, and the parties don't resolve, and they say, well, we've gone through the process, no one can tell us what to do. So there's a conflictual element about the idea of dispute resolution that isn't litigation, but it can be twisted around to it being a very important bit of dispute resolution. I think
that's really important, looking at it, and the role of the mediator. I'm going to say a few things. Let me start with the role of the mediator and the role of how litigators have taken over the mediator space, initiated. So a lot of mediators are barristers, or and I say, or anybody who's retiring. Can I say everybody plus their dog who retires from law practically becomes a mediator? So they don't necessarily feel as excited about what mediation can achieve than people who, think this is a great resource for resolving disputes. They then go in on the basis of, I can't say enough because I'm going to court, and they don't know that. And the mediator themselves, if they're a barrister, says, I listen to you, I do this, and then you're going to court anyway. And they don't take time. So also the concept is we go in, we quickly do our mediation, and we're off to courts if you can't resolve and you need to resolve quickly. Whereas a proper resolution, especially if things are more complex, takes time. It means using psychology. It means playing games. It makes maybe sending people off to do a little bit more thought processing. So I like the idea of saying we need to reevaluate what dispute resolution is all about. Throw away the word alternative and just say we have dispute resolution. And probably problematically, people think arbitration is alternative dispute resolution to court, but actually it is the same as a court. The structure of it is the same, and people don't understand that. So if we change that, but we also change the way in which people were remunerated. So if you're a lawyer and you manage to get your client resolved within a certain amount of time, and you would normally earn $100,000 if you went all the way to court. Well, maybe you get a bonus from what you settle it. If we had a bonus situation, then suddenly people go, well, there's something in it because I can get my cash flow in. I'm not waiting for 2 years to go into court, and I get well remunerated up front. Yes, I might not get $100,000 over the next 2 years, but I'm going to get a nice settlement. If this settles, I'm going to get a nice fee. It's thinking differently and promoting it, but that's we have to change the way of thinking within the court.
At least there are two things there, and I'm sorry, I'm taking over.
I'm loving it. I'm loving it.
I'm really involved, and we've done so much work when we've moved into, because I'm a former lawyer, litigation lawyer, and that's what I've done, and I've moved my thinking totally. So the issue about people in the space, and we're in a different space to you, right? It's similar but different. Family law is very, very different to commercial. There is that element of the unlearning, because every family lawyer has been in a practice, every young lawyer has been in a practice with older lawyers who have been taught by older lawyers, and it was all about court. Everything was about court. That is what being in a dispute situation or conflictual dispute situation, whatever it may be. The unlearning has to be, no, you are very skilled and expert at resolving matters, resolving issues, not conflict as such. Don't focus on conflict as such. Look at resolving issues, and the mindset must change when you do that. And secondly, you've made a brilliant point that we've been banging on about, and we have a real issue here in Melbourne with the barrister mediator model, which is so entrenched in Melbourne that we as solicitor mediators find it very hard to be considered as a mediator, because everyone thinks barristers, they have the knowledge of law, which apparently is really important for a mediator, I don't think, and they will know how to beat one or other of the parties into submission if they don't agree. So it's almost it's almost a session by submission methodology rather than a mediation to resolve issues that people can't resolve themselves. And then when we get to that, the last point I make is, because it comes out of the barrister mediator scenario, where does the idea of a one-day mediation necessity come from? Whenever a mediation is booked and you go to the barrister mediators, they say, oh, the daily fee is X. And you think, well, sometimes it's too much for parties, especially in a matrimonial situation, to concentrate from 9:30 in the morning until 4:30 or 5 in the afternoon about all of the complicated and interrelated issues. Why isn't mediation considered as a process, not just as a once, if you resolve it, good, if you don't, well then, as you say, we're off to court. So the whole unthinking of what is the methodology that needs to be considered to get you to outcome, rather than how do we get a mediation done. It's different terminologies.
It's exactly right. It's the way things have been. You've got it with the small business mediations with rent, where they get 3 hours. So you get 3 hours to resolve, or we have a day, or, and we even when we quote for our mediation, because that's how we work in confidentially speaking, everybody knows fees up front. It's a half day, a full day, or if it's complex. And we, that's the methodology we use. But I see negotiations take time. When I deal with, like, I've got one matter at the moment where it's a business transactional one. We don't just walk in and say, well, we're going to resolve this like merger of the businesses in one day. We go in and say, well, today we'll talk about this. This is our term sheet. This is what we're discussing today. Go away, do your evaluations. And with conflict, it's even harder, because although I think in most mediation there is the slight conflict of I want and will you give me kind of concept. But in a conflict, you've also got the poison that you're dealing with. And so you've got a huge psychological issue that's going on, because the parties are aggravated, they're upset. Very rarely in a conflict situation, even in a commercial situation, are people feeling, we just got to get together and resolve it. Even, there is this poison that is sitting under it, and you want to say to them, deal with the poison and sort things out. And then we're going to have a barrister who's going to, I've seen this, put their foot up on a chair and stand over a person and scream at them as to why they are being so obdurate, and they're going to have to go to court, and it's going to cost them a fortune. And trying to unpack that is really hard. I've been focusing on trying to get in early instead of later. I sometimes get a call. I got a call from a solicitor who's quite high up, and he said, oh, could you do a mediation tomorrow afternoon? I went, tomorrow afternoon? He said, how much preparation is there? Because I like an intake process. I like the whole So, but and he said, oh, well, you just won't prepare. We'll just go in. And I said, no, sorry. Like, I've got to get a few days and I've got to meet the other side. When am I going to do that? I've got stuff in the morning. And he was like, oh, yeah, well, I'm not available. And I was like, well, that's fine, but it's not about you. It's about your client. And I've got to meet your client. Your client has to know me and trust me because it's not about you. That's why I'm there. But it's trying to relearn, and you might not get briefed again. So you have that problem as a mediator. But people get angry with me because I say I'm not really interested in you. I'm interested in your client. And so you do take a risk, whereas you might feel like we do. But then if you say to the solicitors, this is not the way to do it. Your behavior is bad. You've got to rethink. Then you run the risk that you might not be briefed again. So we really have a huge issue to move through.
And Elise, it is the issue of there's a form of a cookie cutter mentality about mediation. And that's because it is not properly understood. And whether it's mediation or even if it's conciliation, where the mediator or the conciliator obviously has a bit more of a directive role, it's still not understood. I mean, back in family law, with the greatest respect, apart from the Conciliation and Arbitration Commission back from the 50s and 60s, family law was the one that brought up mediation as a necessary precursor to continuing in family law. And it was a 2-hour session, a conciliation conference early on, way back in the 70s, and it was a 2-hour concept. The negotiation could continue afterward, but the conciliator wasn't necessarily in the process. So we've got a number of rethinkings, but most people have entrenched themselves into that's the way they do it. And as we all know, people go to the point of least resistance. Why should I look for another mediator when I can ring up a barrister's clerk and get the name of 3 of their mediators? I don't really care. It's like picking dishwasher liquid off a shelf at the supermarket. They're all the same. I'll just get one. We'll go through the motions. If it settles, how good's that? If it doesn't matter. I'll make some more money, ka-chink, ka-chink, and we'll be into. So it's almost a process rather than what are we really doing it for? As you say, it's not about the lawyers, it's about the client. It's not about the mediator, it's about the clients.
Yeah, exactly.
So can I just say I'm absolutely loving this discussion. I feel like I'm almost doing a panel discussion here. I'm absolutely loving it. Can I just say to both of you then, so where do you think, because obviously education, it's that rethinking, relearning, reprogramming our view around all of this. Is it with the client or is it with the lawyer or is it with both that we need to do this?
It's with both. I would say you have to use both of them. You can't just, but I think the important thing my belief is it's got to come from the client, because the lawyers have been doing this for far too long and it works for far too long. So why would they change their model, right? But if the client suddenly says, I'm not interested. I want to do this. And so it's a lot of education. Part of what I do is I do speak to small business. I do speak to people outside of it. And I try and inculcate you are the power in the negotiation, not your lawyer. Your lawyer is there to guide you and give you a legal framework and maybe give you an idea of the experiences. They might have seen 5,000 negotiations, so they can bring that up. But at the end of the day, it's yours and you get to choose, and you've got to start being empowered by it.
100%. And how important is the business model? Because you touched on this, Elise, where you were talking about, the incentive in terms of the traditional hourly time recording. It is absolutely pointed towards litigation. That is where you're going to make your maximum revenue on that time, right? Because it's 2 years of your life you're giving. So how important then is that business model? Because it was really interesting in a previous conversation we were talking about with a firm that does a subscription-based offering, is this whole concept around, value and understanding. So you're actually saying to the client, well, how much would you what is the value of this if we resolve it? So the conversations are not, if we go to court and battle this out and I take up 2 years of your time and probably destroy all your personal relationships and your business, but what would you pay? And the beautiful Sean Jardine, Barry, I know you've heard this story before, but at the Legal Iconoclast conference, he told this wonderful story about a client when he was practicing called him up and said, I've got this employment law issue. I just want it resolved. And Sean said to him, well, how much would you pay? And he said, oh, I'd pay $10,000 for this to go away. And he said, all right, I'll take it. It took him 5 minutes to resolve. He got paid $10,000.
Yeah.
Now, the client was happy because the client was like, I said I'd pay that to get it off my plate.
Yeah.
But it took him only 5 minutes worth of his time. And this is why in these things, the model is so important. Is that right?
It is. Like it is. I mean, it swings and roundabouts. Like, you know, I had a client say to me, how much is, she said, you know, they claiming, and it was a small amount. I'm just going to make this up. But she said they're claiming 30,000. Maybe I should pay it. So I said, well, do you owe it? And she said, well, no. So I said, so is it worth spending $2,000 to try and get it out the way? Because you're prepared to pay 30 and you don't owe it. How about 2,000 thrown away costs to just for me to review it and give you a strategy? And it was the same thing. Within 2 seconds, I said, well, you don't owe it. This is the letter, and we'll write a letter and we'll fight it. And then we can see. And the reality of it is they resolved like $1,000 walk away cost. So it cost her $3,000 instead of 30. You know, it's that kind of concept of saying, well, if you owe the money, pay the money, right? Maybe offer a discount, but pay the money. But if you don't, it's worth your while to spend some money on me and feeling, but this is where the problem is. You've got to have the guts to come up with a good figure, because I found over time I'm getting better. You do battles to find out the quote of that. Yeah, you underquote a lot, but I'm getting better at that.
I think just popping in on that, of course, in our area, money is code, right? I want a settlement of X, or I don't want to pay a settlement of Y. That's code for he's a dirty bastard or she's a dirty bitch and needs to be shown.
Yeah.
And the amount of money has got nothing to do with that, because even if the settlement was you get 1 million or you get 1.2, is that a difference? I'm not really sure. But you don't understand what a bastard he is, and he wouldn't even pay him. And so, you know, your psychology concept, Elise, is so important in that. It's not about what people put in front of themselves and you, it's what's behind it all. And clearly that's not something you get in 1 or 2 hours, because you're unscrambling an omelette that's taken years, if not decades, to develop. So the idea of value, Karen, and you know this, you know, we've had many discussions about value and pricing value, or getting people to understand it. It is an education of the community, and the community is not aware of the talk that we have. When I have my intakes with a lot of clients who have lawyers as well, they don't know what mediation really is, because they're in a fog. And you're just throwing another word at them that is not a common word. It's another process they have to get their mind and their emotions around. And they're not really understanding or listening. It's not as simple sometimes as, do you owe X or will you pay Y? It's you know, that's very binary. So the concept of dispute resolution and the person who is conducting or directing it needs to believe that people do have an understanding. And I think you come from the position of they don't have a proper understanding. And also they have a veneer of what the lawyer puts on top of them as well. You know, we'll go to this mediation and we'll show them our position. And, you know, so the client's all G'd up about whatever that is.
Well, you know, I had a barrister say to me, well, the important thing is to show that you beat someone up on behalf of your client. And so, like I said, well, I don't want you in the room.
No,
you know, because so she actually did. And she said that. I've got to show them that I can beat them at it. And my concept is you've got to stay out of it. You have no idea. You're a combat artist, and of course you go to court to beat other people, but the clients.
It's at least like that mixed metaphor of you're taking a hockey stick to a football game.
Yeah,
you may be a great hockey player, but you're in the wrong arena.
Exactly.
Oh my God, this conversation is so good. All right, I did say that we would talk to some of these other tips. So
yes.
Okay, one of the other ones I wanted to ask you about. So one of your tips, Elise, has been if your position is non-negotiable, clearly communicating the reasons as to why is key to gaining the understanding and respect of the other side. Talk me through a little bit about that. Is every position non-negotiable? And is that so talk me through that one.
Okay. So the thing is, when you do your preparation, which is key, like if you don't prepare, you don't know always what's non-negotiable and what's negotiable. So importantly, in your preparation for the negotiation, you would have looked at what is non-negotiable. When do I walk away? I was saying you've got to know when to hold them, fold them, know when to walk away, and know when to run. So when you decide you're about to run away, you've got to have your runaway position, because walk away means maybe come back. Run means I'm not having a bar of it. And you've got to have that in your mind when you go into a negotiation, because because when people start talking, you can get caught in you can go down different rabbit holes and find yourself in a position that you weren't expecting, but because you haven't got very clear ideas of where you're heading and where you need to walk away, this causes all the issues. So you do need to know what's non-negotiable. It might change. Someone might give you an idea and you go, oh, maybe that wasn't so non-negotiable. Then you need to stop and go away and consider that. But if it is non-negotiable, you still need to explain why, right? You need to say, well, it's non-negotiable because for me, I can't live on if I'm taking the family law concept, I can't live on this and I've got kids to bring up and they're your kids, right? Or it's like a commercial concept. Well, I need to make X amount of money on this deal. Otherwise, it's not worth it for me. The cash flow, the amount of effort I've got to put in, it's just not worth it. If you do it, good question. I've just seen Tremaine's put something in the chat. If you do that, right, they then understand and maybe they'll come to the party. So if you're being very clear about why it's non-negotiable, I mean, I've seen a number of times when someone said, it's just not worth my while. I've got to put people on it. I've got to spend the time. I know this sounds good to you, but this is how I've come to this position. They often think, okay, well, if I really want this deal, I need to understand their non-negotiable position. They might think, well, I can never make this. I've seen this happen, but they go, for us, it's not worth our while to spend this or spend this time with the people. But at least you know, and at a later stage, you might think things have changed and you might go back to that person. And so I understand how you work, or could you do something a little bit different? Could you do something a little bit different to work around? So maybe we can't get the full deal, but maybe we can get a half deal. So I'll give you an example of someone who's working, doing some outsourcing work for me. They came in with a huge amount of money that they wanted me to spend monthly. And I said, I'm a fledgling business. I can't afford that. But how about, this is what I really love. And then when we need to do, and they said it's non-negotiable for us because this is our package. I said, but I'm fledgling, but what about we have you have your monthly model that you need a subscription base. Maybe I can take a tiny bit of that, and then when I grow, you can grow with me. And also, I've done some acting for them, but also I kind of said, well, I understand, over time we'll do bulk work instead. Can that work within your model? And they said, well, given the small amount you want us to do, it's easy for us to do. But if they hadn't said for us, it's not worth it, I couldn't even begin to change because we just have been playing games.
And flowing on from Tremaine's question, so how do you manage a non-responsive party?
horrible, aren't they? They don't tell you anything. I then tend to say, look, I've put forward my position. It's clear you're not responding. Should we put it in writing and you go away and you come back to me in writing about where you're headed? Because you can sit and look at people all day, but if they're not responding, there could be a reason. Sometimes I find, I'm very talkative, as you can see, and I like to think on my feet, and maybe to my detriment sometimes. But there are a lot of people who get intimidated by the whole situation, or they're playing games. And so the more they're unresponsive, they might be expecting people to keep talking and give away because, oh my God, you're not responding to that. Then maybe I need to throw in something else, and you start negotiating with yourself, right? Because the person's been like, they've been quiet. It's like, no, you have your position, you put your position. If they're not responding to it, it's fine. You can say, do you have anything to say? Do you want to comment on it? And then call it, say, look, you're not responding. Do you need to walk away and come back, and we'll wait your response? Do you prefer to do it in writing? Do you need time? But don't start upping your ante when they're not responding to you.
That is so good, and particularly that point that you made about don't fall into a trap where you're negotiating them with yourself. And I can see how that could easily happen. So almost kind of going, right, okay, they're non-responsive. We're going to stop. We're going to take a break. I'm not going to fall into that trap, and let's see what we can, to still continue the negotiation, but perhaps maybe meeting them more on their terms, which I think.
And I wonder, sorry to butt in, but from a mediator's point of view, if the mediator gets to that point, because it's almost the end of the negotiation or mediation, maybe the mediator can say to the non-responsive, what will it mean to you if the matter doesn't resolve today?
Well, that's when the mediator would call them into their private group and stop it. So the mediator, as a leader, would call it and move them away. But if in your own if you don't have a barrister who shits all over you, sorry, I'm being mean to barristers. I'm being so mean to barristers. So I have to add in, I've had some really good barrister judge mediators, but they are the exception. But as a leader of the negotiation, you should call it. But if you're on your own, Tremaine, does that answer? Do you have anything else flowing from that?
I'll let Tremaine put something in the chat she's given it a cheer on that one, which I really like. And I think again, just re-emphasizing how important it is to have the right mediator or the right person in your corner, because like you say, that person has a lot of them control and power. Whereas I guess if you had and Stella's just put something in there. On
my own negotiator. Yeah. I'm in with that, Stella.
I know. I love how important it is, because that person then can direct it. Whereas if you've got a very a particularly adversarial mediator who's just ticking a box and thinking we're going to go to court anyway, they're not going to do that. They're just going to go, oh, well, it's all over, and there you go.
Sorry, and we get back to the preparation, isn't it? What we call the intake. Our intake is with the parties themselves, and you don't know how much of the spiel we give them about you've got to be ready to negotiate, but also to make compromises.
Yeah.
If you come in with just one position, then you might as well forget it.
Yeah. I've stopped using the word compromise, Barry.
Okay, yes, interesting. Give me another one.
I say you might have to move your position slightly to take into account the other person's feelings and needs. And the reason I do that is if you start saying compromise, I say, going into negotiation is 50-50. So I've stopped using that.
Very good commentary.
I say you might have to move your position, and that's why you need to know when it's unmovable.
Because of course, Elise, in our world, compromise is what it is, but you have to put it in other words because people out there don't think that way, and they can make compromise mean whatever they want to mean, and it'll usually be, from a cynical point of view, you're trying to put me into a position against my interest.
Okay, so I've got a few here. How about non-responsive colleagues? I'm hoping, Stella, you do have non-responsive colleagues. That's what I call the puppet master needs to take part in the negotiations team. Your non-responsive colleagues, you actually, I say part of your preparation is working on who should be in the room with you. And then you have to have the puppet master. That's the person in control of the negotiation. So I always figure out who's the best person to control the mediation and all the people on my team. And sometimes you want the non-responsive colleague to actually unnerve the other side. So you might put them in, throw a question to them, they're not responsive, and it unnerves the other side. Sometimes I would say, look, can you just give me everything you need and be on the phone and we'll come in. So it's the person, you part of your negotiation team at the negotiation team is who should be in the room, and who should be speaking and who should be controlling. And then what are my thoughts on, given it is a non-predictability comment?
I might just say the question, just so people know if they're listening to the recording. So it's, what are your thoughts on mediator reports, given it is a non-prejudicial discussion regarding the ability to comment on a party's unwillingness to cooperate, non-responsiveness in mediation?
Yeah, I don't, personally, I don't like to give that kind of report out. I think part of mediation is you have a right to be there or not. But I know that in the, under the law, so for example, in the Civil Procedure Act, you have to show that you were in good faith. And if the person wasn't in good faith, the other party's got a right to say they didn't come in good faith. I would very seldom give a report like that. But if I found that the party had been exceptionally in bad faith, I wouldn't have a problem just saying, they'd never complied with that part of the act. But I would prefer not to. They'd have to be in exceptionally bad faith.
Thank you. This might be our last question, but I'm asking for a friend. Okay, I'm actually asking for myself, because this is what I do a lot. I fall into sales mode. So how do you negotiate without falling into that selling your position to the other side? So keeping it more in the realm of negotiation rather than selling, because I do that a lot. I go straight into, well, I'm trying to persuade you to my side rather than actually staying purely in with it. We're negotiating.
So one of the arts of negotiation, sometimes you want to do that. Sometimes you want to go in. So this is like the strategies. How do I go in? Who is on the other side? Do I need to go in and do I need to anchor the discussions? Do I need to take control and say, I'm coming in, this is what I want to achieve, this is how I want to achieve it? And that might work. I always say it depends. You've got to be flexible, you've got to move and shake. But I find the best part of it is to go in and be, firstly, think in your mind, I've got to be flexible because I'm not sure, even if I know the other party, I'm not sure how they're going to behave in the room. And the second thing is I need to listen to what they have to say. So often I say, can you just tell us a little bit about where you're at and why you're at there before I come down? But part of that is also important. I say this because listening can help me reformulate what I'm looking for in their language. So if they come at a certain thing, as I see their anxiety on certain terms, if I see what they're looking for, and I can then move what I'm looking for in a way that they can hear, because I'm reformulating my position in a way that is more in tune with where they're coming from. When I go in and I play heavy sell, as I say, it might work, and there are times to do it. They might feel it might turn them off. It might turn them off. And you using your language and your formulation, it's sometimes easier to put what you want in their formulation. So always, I often go in and say, let's just talk about where you're coming from, what you're hoping to achieve today, and what your concerns are in relation to that. And I use often psychology of it. No.
So very powerful. And I feel like we need to do these like live with Elise. And Barry, and everyone can come with all their questions and their things, because I think what you're both doing as well is you're kind of almost giving us a peek behind the curtain from a mediator's perspective as well about what you're doing, which I think is so fascinating, particularly for younger lawyers out there that, you know, you're giving us some really good things. But things that and I'm going to give you, Barry, because I see you've moved forward, the last word on this, but just to kind of wrap this up, these are the things that I've taken. Education. We need some reprogramming. We need some relearning, and perhaps it's sitting mainly with clients. So people like me need to be talking more to clients going, you know what, it's not, litigation is not sexy, to use your phrase, Barry. It's not sexy. It's expensive. It's emotional. It's traumatic. And, you know, it destroys things. So really, it's not alternative dispute resolution. Everyone should be focused on, you know, resolving the disputes and be in that resolution mindset. The other thing is selection of mediator and the person controlling the negotiation. So important. You've got to have someone that's on that board. They're not ticking the box. They're not looking already to the litigation in court. They're actually wanting, and they're coming in good faith and can do it. Master communication skills is really important, isn't it? It's that ability to be quite emotionally intelligent as well. And, you know, if you're bringing your client along, providing that really great communication skills. And the other thing I just had, and the business model, obviously, I think we've got to look at as well. The other thing I just thought of, and maybe this is a question we can leave on, but, you know, I think when I was many years ago, when I was looking at mediation in the commercial law context, and we often looked at family law and said, well, they've got it right because they've made it mandatory, and therefore everyone's going into that mediation process. Is that a good or a bad thing? Because I think listening to both of you, what it's kind of made me realize is that perhaps isn't the answer, because all it's done is it's just made it another step in the process to the court, to the litigation, as opposed to it being the process. And so, yeah, I guess views on that.
I would say that I think the issue is that it becomes part of the court process. So you have, for example, my experience, I was in banking and finance. The registrars ran mediations. The registrar, I mean, it was bizarre. But it still happens. And today they still do, like they run the mediation. So the person who's actually organizing the mediation, whether they're barristers, I'm sorry to say, or judges or registrars, are all part of the court process. What you really need to say is this is my financial model as well, but what you really need to do is, if you go for mediation, but outside of the court. So there is a mandatory mediation, but it's mediation outside of the court. You go to mediators who are not part of the court process. I know barristers will never allow this to happen, but be that outside of the combat artists of the barristers. I mean, some of the best mediators I've had are not lawyers. The finest mediator I know is a quantity surveyor, because he's practical and he knows his stuff. So if you move that, I still think it's important to embed in people the mindset that you should try and settle before going to court, and mediators are a good opportunity. It doesn't have to be them. You could do it yourselves, right? But that mindset of, I must always try and settle, it's much better than going to court. But yeah, I'll let Barry continue.
Just one thing, and I take your point, Karen. Education is it, and I think there is severe lacking for us lawyers. Forget parties for a minute, but lawyers in negotiation skills. It's not part of the teaching process, and the way lawyers tend to learn how to negotiate, they pick which senior person they've seen and model themselves on that, which may or may not be right, but then it just becomes ingrained. And we need a lot more education about what negotiation is, and not necessarily from lawyers. Negotiation happens, as we know, in the world everywhere. And it's not just about a legal outcome, it's about all sorts of outcomes. So if we take it out of the context of you're in a legal process, therefore it must follow a legal way, that's not necessarily right. So I take your point. Thank you so much, Elise. It's just so edifying.
And there you have it, team, our new pin-ups of negotiation and mediation, Elise, Margow and Barry. Barry Berger. There you go. We can have you as your pinner. I'll get some
Yeah.
posters made up on the wall, and we'll have you there as our role model. I will just say this: we have hit over the 1:30 mark. I just want to say what a privilege and an honour to have, been and just observing this conversation. So incredibly brilliant, Barry. As always, you provide so much incredible knowledge and wisdom as being part of it. Elise, I'm going to give the last word to you before I end the recording.
Well, I think, Barry, we've got to keep having the conversation. I've just loved this.
I agree. All right, I'll bring the wheelchair, Elise, and we'll go and have lunch.
That's fantastic. I really enjoyed it. And let's just keep the conversation going about changing the way people think about negotiating and mediating.
Love. Thank you.